We're with David Shapiro. David is a criminal defense attorney in San Diego, California, and he's agreed to answer an online question that was posted. This question is specifically related to statutory rape and if you can be charged even though you did not think the person was 18 years old. With that said, the question was, well, this isn't his real name, but Art. Art says, I was at a bar downtown San Diego having a few drinks, and I met this girl. We ended up going back to my place, and we did have sex. The next day, I was arrested and charged with statutory rape. It turns out she was only 16. She had told me she was 18, and I believed her. Can I still get convicted for this?
Art, I hate to break it to you, but I think you can. Not saying you will. Hopefully you won't. And the main issue and the main focus would be, even though you have been arrested on this and it looks like you've been charged, the first goal would be to try and prevent charges from being filed at all. And the second goal would be to try and resolve the case if charges in fact are filed for something that does not involve registration as a sexual offender for the rest of your life. And that's a big problem with these types of cases is on any sexual assault case that's usually in play. Now, you're presumably at or over 21 years of age because you were in the bar yourself, and I'm sure you thought that she was as well. The age difference, the law looks a lot more favorably and treats less harshly people who are 19 or 20 who might have sexual relations with someone who's 16 or 17. And they view more harshly someone who might be like 27, 28, who might be accused of having sex with someone who's 16 or someone who's certainly over 25 years of age. So, you have all those factors going in there. The fact that she was at a bar where she would have had to have been dishonest with someone to get in and drink alcohol, the law being 21, excuse me, and up in California, to be able to get into a bar certainly helps, but it doesn't help as an actual defense. It helps more as a mitigant. What I mean by that is, factually speaking, the elements of the offense, sort of like a strict liability offense to a large degree. If you did it, she's under that age, you're on the hook for it legally. The issue is whether it's appropriate to be charged and whether it's appropriate for you to be convicted of it from a mitigation standpoint. Is this the right thing to do under these circumstances? It would be important for your attorney to relay to the prosecution and to the court that this is gravely a misunderstanding, and certainly was not your intention to have relations with someone who is under 18, let alone someone who is under 21, based on the situation you are at. So I think if things are relayed that way, hopefully you can work out a favorable outcome that does not involve being convicted of what you're charged with, because then you always face the variable option of having to register as a sex offender for the rest of your life. And this is certainly not the type of fact pattern I think that the law was made for.
Excellent. If you have any other questions, feel free to post them in the comments section below. And thanks for your time, David.
My pleasure. I can also be reached at my office, 619-295-3555.